There being no objection, it is so ordered. The question is? The question is that the bill stand as printed. Yes. Do I say? Yep. Yep. Senator Kovacic. I call Senator Kovacic.
Thank you very much. The Coalition supports penalty rates. We've been very clear about that. We support penalty and overtime rates as fair compensation for working unsociable and unpredictable hours. We also support employee choice. We support employee flexibility. We support employers and employees being able to negotiate amongst themselves what works best for them. The Fair Work Commission already has appropriate powers to safeguard penalty rates through the Better Off Overall test. These are all given. These are all facts. These are things that we know. We have concerns in relation to this bill as to how they create impacts on small business, the retrospective application of this bill, the ambiguities of its implementation, the impact on employee choice, the risks it poses to working from home, the effects of EBAs and IFAs, the mischaracterisation of loopholes, the impact on productivity, and the risk of capturing legitimate above-the-award arrangements within this bill as an unintended consequence. Australian small businesses are struggling. There is no question about that. It doesn't matter whether it's a business in retail or hospitality, a business in construction, though those two are the ones that have the highest rate of insolvencies. And that is a legacy of this government. That is a legacy of the Albanese Labor government. This government has presented over 35 significant changes in terms of legislation that impact small businesses. That is roughly one per month since this government has come into power. That is an extraordinary impost on Australian small businesses and in the way that they operate. We had a productivity roundtable last week that this government held in order to find out how to improve productivity, because we understand that that, amongst many other things, is a major problem in this country. And on the back of that, this week, we have this bill in relation to penalty rates, which makes it harder for Australian small businesses to operate, because it creates yet another layer of regulatory burden, red tape and financial impost connected to that. And the question needs to be asked, why? The question needs to be asked, what is the actual purpose of this legislation when penalty rates are actually not under threat? The Fair Work Commission already has the ability and has the remit to make sure that there are no impacts to workers in relation to preserving their penalty rates or protecting their penalty rates. But what this bill actually does do is constrain the Commission. It undermines its independence, and it risks unintended consequences in award variations. And something that we need to have a clear understanding from in relation to this bill from the government is where the bill could operate retrospectively, creating uncertainty and exposing employers to union-driven variations of existing awards. So what does that mean, union-driven? It means that the union must be involved in those negotiations between employees and the employer, rather than them sitting down together and having a discussion about what works best for them. Having a face-to-face discussion about what the employee would like and how that works for the employer and how they're able to navigate that. A simple, basic sit-down discussion. This is an even greater problem for Australian small businesses who then have to engage in complex and costly negotiations that will likely involve an enterprise bargaining agreement and involve the intervention of a union. Whether or not the employee actually wants that. Evidence that was presented to the inquiry shows that small business owners spend some 15 hours a week on compliance. 15 hours a week. That is 40% of the regular working week spent on compliance. We need to pause for a minute and have a think about whether that is actually something that is necessary, or if we have perhaps gone too far, and I would suggest that we have gone too far. And if we're looking for clues and some tips on what is causing the productivity issues in our country, that would probably sit in my top 1, 2 or 3. People are being prevented from working in their businesses, growing their businesses and creating stable and strong businesses so that they can actually employ more people by the imposts of regulatory burdens, many thousands of pages of which have been imposed by this Albanese Labor government. And that's something we absolutely need to address. So my first question to the Minister is around the consultation and the process. And Minister, I would like to understand why this bill was introduced without meaningful consultation with small business organisations, which have expressly raised concerns about its impact.
I call the Minister.
Thanks, Acting Deputy President, and thanks, Senator Kovacic. It's great to have you repping the opposition in this portfolio. As a broad principle, the government is committed to genuine and ongoing engagement with stakeholders, and in developing the bill, we've engaged closely with peak employer bodies and unions. I was just taking some advice on this, and when it comes to small business in particular, the usual small business representative groups that you would expect, people like COSBOA and ACCI, were present, I understand, at the National Workplace Relations Consultative Committee, I think is what that acronym, Council, where this bill was discussed. We did comply with the government's consultation obligations for workplace relations legislation. We consulted on an exposure draft of the bill with state and territory government officials, employer groups and union members of the Committee on Industrial Legislation, another acronym, COIL. This is a subcommittee of the NWRCC. This consultation was held on a confidential basis, but it has led to a stronger bill, and we thank participants for their valuable engagement.
Thank you, Minister. Would you be able to tell us how many actual individual small businesses were consulted, and noting the privacy elements, just the number?
Should I call the Minister each time? I call the Minister. Yeah.
As the Senator would understand, the usual practice when it comes to legislation is to consult representative bodies who then consult their members. So I would imagine that groups like COSBOA and ACCI, among others, would have consulted their membership, which in those cases would have included small business.
Senator?
Thank you. Noting that, would you be able to tell me why the repeated concerns of industry bodies like COSBOA and ACCI were ignored, and the ACI group, in relation to the drafting process, where they gave specific recommendations to take out ambiguity, and that was not considered?
Minister?
Of course, Senator, the fact that you consult on a bill doesn't necessarily mean that you take on board all of the feedback that you receive, and I'm aware that the ACTU had views about this legislation, some of which was not taken into account as well. Just because we consult with different groups doesn't mean we take on board what they say. But an amendment actually was made to this bill in the House based on feedback we'd received from employer groups, including the AI group, regarding the retrospectivity point. So there's an example where we have actually listened and taken action on the basis of that feedback.
Senator?
I move the amendment in my name as circulated on sheet 3408.
The question is that the amendment be agreed to. Those of that opinion say no.
It might be useful if I just make a short contribution.
Just leave. Doesn't need leave. Good.
Thanks. And I might just work out which... Sorry, could you just repeat which amendment that one was?
3408.
3408. Got it. So this amendment, if I'm looking at the right one, or it's a suite of amendments to change the scope and parameters of the principle by providing carve-outs, exemptions and competing factors for the Commission in making its decision. I'm not sure that the Senator would agree with that characterisation, but that, I think, is what we see it as attempting to do. The government will be opposing this amendment. The amendment seeks to dilute the bill in numerous ways by providing carve-outs, exemptions and competing factors for the Commission in making its decision. Not only does this amendment seek to erode the fundamental purpose of this bill, which is to protect penalty rates, it also looks to add an array of additional complexity into the principle and put additional parameters on the Commission's discretion. I note that complexity and independence of the Commission are two things the Coalition has criticised this bill for. We've consulted genuinely and transparently on this bill with unions and employer representatives. The bill's been through a Senate committee process where stakeholders were provided an opportunity to publicly provide their feedback. The outcome of that process is clear that the bill should be passed. As a statement of principle, the government believes that every award-reliant worker deserves protection of their penalty and overtime rates. For those who rely on those penalty and overtime rates to make ends meet, this bill gives them certainty that their take-home pay will not go backwards.
Senator Kovacic.
Thank you, Minister. Noting your comments about engaging genuinely and transparently, are you able to confirm for me whether any of the stakeholders involved in the process were required to sign a non-disclosure agreement?
Minister.
I think I actually answered in one of my previous answers that what's known as the Committee of Industrial Legislation process, which is the formal mechanism that the government has consulted for some time through when it comes to workplace relations legislation that involves consultation with states, territories, employer groups, unions. I think I said previously that they were confidential discussions. What I'm advised is that the process there is that all participants in that process sign a non-disclosure agreement that lasts for 12 months and covers every bit of legislation that comes up in the meantime. So we follow the standard practice.
Senator.
Thank you. Minister, how does the government justify introducing the 36th major change to the Fair Work Act since 2022 when 34 of those changes have disproportionately affected Australian small businesses?
Minister.
Well, I don't need to look at my talking points for this one. That's because this government, since the time we were elected in May 2022, made very clear that we intended as a government to lift Australian workers' wages. We wanted to get wages moving again. We were coming out of a 10-year period of coalition government that had deliberately suppressed wages, that was affecting living standards, and we continue to make no apologies for introducing a series of amendments, including these ones, which are about getting wages moving again and allowing Australians to deal with cost of living pressures. And I'm not sure what the opposition's position really is on this bill, but we'd like you to support this one as well.
Senator.
Minister, I'm impressed by your lack of need for talking points. Well done. I acknowledge your comments in relation to lifting wages. I want to get an understanding of the scope and the thinking around, again, the impact to Australian small businesses. You have an awareness that we are in a housing crisis in this country. The highest rate of insolvencies is in construction businesses. And again, I speak to the 36 major changes, or this would be the 36th major change for Australian small businesses. What was the consideration made as to the impact to Australian small businesses of this change, if any?
Minister.
Well, I might just start with a broader answer around how we've approached the range of workplace relation changes we've made in relation to small business. And we have always acknowledged in each piece of legislation that we've passed since being elected in 2022 that in some cases small business does need further time to adjust to changes than what we expect of big businesses. So, for example, just this week we're celebrating the 1-year anniversary of the right to disconnect. That has only just come in as of this week for small businesses. It came in for big businesses 12 months ago. There are other changes that we made, which I've forgotten for the moment, which applied to big business in the first instance, and 12 months was given for small businesses before the requirements came in for them. So that would be an example of how we have attempted to consider the different needs of small businesses when making some of these changes. On this bill, I guess there's a fundamental point to be made, which is this bill is not altering existing conditions. It's not imposing new obligations. And I've heard Senator Kovacic and other coalition senators talk about new obligations, onerous burden. What it's about doing is preserving existing conditions rather than allowing them to be cut. So this bill does not alter existing employer obligations, including those of small business. It does not introduce new costs or impose additional requirements on small business. Modern awards are industry or occupation-based instruments that provide a safety net of minimum terms and conditions for Australia's lowest paid employees. And we think that every Australian employee deserves the same minimum protections in modern awards, regardless of whether they're employed in a big business or a small business. So it's not about requiring small businesses to do something new. It would be about businesses, large or small, reducing and cutting the existing conditions that apply under modern awards. So if all they need to do is keep doing what they're doing rather than doing something new.
Senator?
Thank you, Minister. I guess there is some dispute as to whether that is actually the case. Primarily the issue is that Australian small businesses could see current agreements reviewed based on the retrospectivity of this legislation. And so this bill actually applies identically to a small cafe with 3, 4 or 5 staff as it does to a large multinational corporation with thousands of employees, despite having significantly different capacities to manage regulatory and HR compliance. So would the government actually consider, on the basis of those concerns of carving out or providing that additional time to Australian small businesses, as you've just articulated you have done historically?
Minister.
Well, I might answer that question just by dealing with this point around retrospectivity, which I know has been a concern of various groups around this bill. As with all changes to the modern awards framework, once the bill is passed, which we expect it will be, parties will be able to apply to vary modern awards in line with the amended framework. So it's prospective in its operation. Even without this legislation, applications could be brought to test existing exemption rates against the modern awards objective. This reform strengthens protections that already exist. However, nothing in this bill requires the Commission or parties to take immediate action in relation to existing exemption rates, except to comply with their current award obligations.
Senator?
Thank you, Minister. I'm just a little bit confused by what you just said, because in that same sentence you said nothing will change, but you did say that, if I understood correctly, that there is ability to test existing exemption rates, which means that is a retrospectivity because the existing exemption rates already exist and Australian small businesses effectively have those or may have those. So if they can be tested, then that would mean that Australian small businesses would actually have to do something on the basis of those agreements being tested, even though themselves or they themselves and their employees are making no change.
Minister.
Really, in terms of what I just said, really it's about stating the principle that has always existed, which is that parties can make applications to the Commission to vary awards. So we're saying that ability for a party to make an application to the Commission to vary an award applies now in relation to this point, just as it has always applied. Senator.
Minister, I'm going to read to you a quote from the ACTU from the hearing a couple of weeks ago. They said, the amendments will also apply to awards made before the legislation's commencement. This will enable unions to make applications to vary existing award terms. For example, requesting the Fair Work Commission to use the new principle to remove exemption rate clauses or other loaded rates provisions, such as annualised salaries, where they have the effect of reducing the additional remuneration employees should otherwise receive. Minister, can you please explain to me how this is not retrospective? I can't see how you can deny that this is not retrospective.
Minister.
Excuse me. Again, Senator, all I can say is that parties have always, do always and will always, depending what future governments decide, have an ability to apply to the Commission to vary terms of an award. So my interpretation is that the ACTU is stating the obvious, that parties can apply to seek to vary award terms, just as they could yesterday, they could the day before. So nothing changes in terms of that ability because of this bill.
Senator.
So just so I'm clear, the ACTU is right in what they stated, that the amendments will also apply to awards made before the legislation's commencement, which in my understanding makes it retrospective.
Minister.
At the risk of repeating myself, the bill is not retrospective in its operation, in the sense, for example, so any decision that the Commission makes based on an application to vary the awards would operate from the date of that decision rather than looking backwards. So it's not retrospective in the sense of changing people's entitlements from a year ago, 2 years ago. It's about changing the existing terms of an award, and that change would operate prospectively rather than retrospectively. And again, people can and do seek to make changes to award conditions every day of the week in the Fair Work Commission.
Senator.
Thank you, Minister, and I don't like to make you repeat yourself, but I just want to get this right. I don't want to get this wrong, because this is something that is really important to Australian small businesses and to how they can effectively operate and continue to employ people in our country. Again, the ACTU said the amendments will also apply to awards made before the legislation's commencement. So is the ACTU right, or is the ACTU wrong?
Minister.
Well, it's for the ACTU to decide how they express themselves, and I'm not going to say whether they're right or wrong, just as if you present a quote from Cosboa, it's up to them what they say. What I'm saying is that every single day, employer groups, unions make applications to the Commission to vary the terms of an award that may have been decided years ago. That is normal practice, and that will apply here as well.
Senator.
Thank you, Minister. So I apologise, I probably wasn't clear. In asking you whether the ACTU was right or wrong in terms of what they stated, I'm asking you in the context as the Minister responsible and in terms of the way that you believe that this bill will apply, as to whether it will be retrospective in the way that they have clearly articulated in their submission. So, effectively, an award changed last week can now be changed next week.
Minister.
Again, even if this legislation was not being introduced, unions, employer groups can bring applications to the Commission to vary the terms of an award. They can do that now. And those changes operate prospectively. Wage rates, other conditions are changed prospectively rather than retrospectively, and that's the same here.
Senator?
To confirm, it's incorrect to state that this bill is not retrospective.
Minister? Double negatives.
This bill is not retrospective.
Senator?
Okay, thank you very much. I think we're all just as clear as each other as to whether the bill is retrospective or not. Minister Kosboa gave evidence that small businesses already spend an average of 15 hours per week on compliance. This is another layer of regulatory compliance for them. I take it that you note that nothing is changing, but clearly things do change because we have a legislation in place or being put before the Parliament to protect something that we have the view didn't require protection based on what you have articulated in relation to the Fair Work Commission's current powers. Can you explain to me why it was necessary to incorporate small businesses into this bill and why they have not been carved out?
Minister.
Well, I think I made the point earlier that the government's view is that regardless of where someone works, whether they work for a major corporation or a small business, that they're entitled to have their penalty rates protected. We're talking about people, typically quite low income, typically women, typically part-time or casual, typically young people who work unsociable hours. My family and I, every now and then, like to be able to get a cup of coffee or something on a public holiday, and I feel entirely comfortable with paying a little bit more in order to have that cafe attendant get a bit more in their pocket because they're giving up the opportunity to have that public holiday. So I think that we've got a fundamental difference of opinion about whether there's a new obligation being imposed here or not. And what this is about, this point about compliance for small businesses, every time award pay rates change, small businesses adjust and pay people the new wage rates. What we're saying here, so this is no different in the sense that this is about preventing the Fair Work Commission from cutting penalty rates, and just as small businesses pay new wage rates when they're handed down by the Commission under an award, they will follow the award. It's about preventing the Commission doing something rather than imposing some new obligation on small businesses that they don't already have. It just affects the pay rates that people working in a small business or a big business earn.
Senator?
Thank you, Minister. I think we all believe that people working unsociable hours or weekends or public holidays deserve the penalty rates that they receive. We don't have any concern in relation to that. Where our concerns lie is as to the necessity of this bill and why it is being put forward in the manner that it has and the impacts that we believe it will have on Australian small businesses. Could I ask, was there ever any consideration given to exempting small businesses? And I note your comment that you believe there'll be no change, but clearly the potential for change is there, and that is an ambiguity, and that is a potential unintended consequence of this bill.
Certainly in the period that I was the Workplace Relations Minister and announced this commitment during the election campaign, there was no consideration given to exempting small businesses. And again, that's because our government's view is that regardless of whether you work for a large company or a small business, that you're entitled to penalty rates. And I have heard the Senator say on a number of occasions that the Coalition supports penalty rates. It seems a little bit odd then to be asking questions about exempting small businesses, because that would suggest to me that the Coalition thinks that it doesn't support penalty rates for small businesses. That would be the only reason to seek a carve-out for small businesses. But to my knowledge, it's never been considered about to exempt small businesses from this for the reason I've explained.
Senator Kovacic.
Thank you, Minister. And just to be very, very clear, we're not seeking a carve-out of penalty rates for small businesses. Nobody has suggested that at any point in time, and nor is that in any way, shape or form even possible. Nor do we seek it, nor do we want it. So this is where I'm confused. On the one hand, you're telling me that there's no material change, On the other hand, you're saying you haven't sought an exemption for small businesses because you think that everybody should pay penalty rates, whether you're a small business or a large business. So which is it? Is it that there is no change, or is there going to be some kind of significant change that you will see coming forward as a result of this legislation that you want to ensure that all businesses comply with? Because that's what we're trying to understand. There either is a change or there isn't a change. And if there is no change, then what is the purpose of the legislation?
Minister.
Yeah, thank you, Acting Deputy President, and welcome to the chamber. Great to have you here as a long-term supporter of penalty rates. I'm not saying, and I don't think I ever have said, that there's no change involved from this legislation. As you say, Senator, the point of introducing this legislation is to make a change. The point is that there's no change for small businesses in the sense that they will continue paying their workers what the award requires them to pay, or if they do have an EBA, then they pay them the EBA rates. What changes is what the Commission can do and the sort of wage rates that can be paid. So what changes as a result of this legislation is that the Commission cannot remove penalty rates in the way that it is currently able to do. And when the Commission hands down its decisions about pay rates under an award, that's what employers pay, whether they be small or big businesses. I've just been searching around for a bit of material on this, but one of the prompts for this legislation was that right now in the Fair Work Commission we've got large peak bodies representing large and small retail businesses, peak bodies representing banks and the clerical industry, who are seeking to cut the penalty rates in the awards that govern their workers through offering rolled up salaries that go nowhere near what people would be earning if they were getting penalty rates. So what changes is that employer groups would not be able to cut penalty rates or seek to cut penalty rates in the way that they are currently able to do. And nothing changes for a small business in the sense that today they have to pay the legal rates of pay to their workers. Tomorrow they pay the legal rates of pay. It's just that in the meantime penalty rates can't be cut. So as long as small businesses follow the law and pay the award, then they've got nothing to fear.
Senator Kovacic.
Thank you. So if a current Australian small business has an agreement with one of their employees that you deem has cut penalty rates, then those are the agreements that you would seek to be changed by this legislation that would then create an impost for that small business. Is that what you're saying?
Minister.
Yeah, I think this point about retrospectivity, and I think the concern that you're expressing is that if an award has previously been altered to reduce penalty rates, that there might be some ability through this legislation to rectify that, to change that. And that is not possible under this legislation. It's about what are the current terms in an award, what do they say about penalty rates, and not allowing those penalty rates in the current award to be cut.
Senator Kovacic.
Thank you. Minister, I note your comments in relation to the Fair Work Commission. Could I ask you why remove the discretion of the Fair Work Commission when it already has the statutory responsibility to protect penalty and overtime rates?
Minister.
Thanks, Senator. Well, the Fair Work Act already lays down rules, if you like, for the Fair Work Commission to take into account when it's making its decisions. So this is simply another requirement on the Fair Work Commission to consider when it's making its decisions, just as the entire Fair Work Act includes other matters that the Fair Work Commission needs to take into account. And as I say, it's very common for governments of both sides of the chamber to make changes to what the Fair Work Commission can and can't consider. And as I've said, one of the reasons that we've acted here is that there are current cases before the Fair Work Commission where we see employer groups trying to cut penalty rates in a way that we don't think is fair. I mentioned the retail award matter that's before the Fair Work Commission at the moment. If and in that case, we've got parties seeking to vary awards, and in any case that hasn't yet been decided by the Fair Work Commission, they'll need to take into account the laws as they exist, which will presumably include this law once it's passed. And we are concerned about what some of the employer groups are trying to do in the retail award matter. In the submission that the Shop Distributive and Allied Employees Association produced to the Commission in this award variation case, they provided evidence of members of their union, shop assistants, who would be more than $1,000 worse off each year, and model rosters that would be more than $5,000 worse off each year under the proposed exemption rate being put forward by the employer. Now, I think, all senators in this chamber would recognise that shop assistants don't tend to be highly paid individuals, and for them to risk losing more than $5,000 every year because of what the employer groups are seeking to do to penalty rates, we don't think that's acceptable.
Senator Kovacic.
Minister, given from what you've just read out that you are relying heavily on union evidence to make your assertion, will you acknowledge then that the question of cutting penalty rates remains contested, and that until the Fair Work Commission is allowed to undertake an objective and independent process, it can't be said with certainty that those penalty rates are actually at risk of being cut? Like the Fair Work Commission hasn't made that assessment. That's an assessment of the union movement.
Minister.
Yeah, of course it will be an assessment of the Fair Work Commission in that case and in every other case, but what we're doing through this law is laying down principles that the Fair Work Commission needs to take account of. And should we pass this law, then those principles will include that you can't cut penalty rates from awards.
Senator Kovacic.
Thank you. So I guess I would probably say that the Fair Work Commission is not being allowed to undertake that objective and independent assessment because we are overlaying the legislation and actually taking away the Fair Work Commission's authority to make that assessment of their own accord. Can you just clarify that for me one more time, and then I'll proceed to a different question.
Minister.
Well, as I've said, it is normal practice for governments of the day to introduce laws that that set, if you like, parameters for the Fair Work Commission to work within, and that's what we're doing here. The Commission will continue to interpret and apply the Fair Work Act, including the new principle introduced in this bill. And they will continue to make decisions just as they have always done.
Senator Kovacic.
Could I ask why the drafting hasn't been tightened to guarantee that exemption rate clauses and annualised salary provisions that have already been approved by the Commission can't be reopened?
Minister.
What I'm advised is that exemption rates will be able to be amended. Sorry. Sorry. Even after this law is changed, exemption rates will be permitted in awards. It's just that they need to take into account this principle around not leaving people worse off, essentially, by cutting their penalty rates. But exemption rates will be permitted.
Senator Kovacic.
That wasn't exactly my question. My question was about tightening the drafting to ensure that exemption rate clauses and annualised salary rates that are already approved, agreements that are already in place, they've already been approved by the Fair Work Commission, that they actually can't be reopened by this legislation. So if there's already an agreement in place.
Minister.
I think we're back to that same point about retrospectivity, in that, right now any party can go to the Commission seeking to vary a term of an award, whether it be about exemption rates or anything else. So nothing changes in that respect, and I guess that's why we've left the drafting the way it is.
Senator Kovacic.
So that'll take me to an example of a retail worker, one that you gave yourself a while ago. It made me think of actually my own daughter, who while she was at uni, she worked at a major retailer and often worked into the evenings, weekends and early mornings, and there are many other people that have done the same. It's often also the remit of single working mothers who work hours that might fit in with their care arrangements for their children. If you have a person who has set up an agreement with their employer that works best for them, that encapsulates the average working hours, and it gives them a set, regular income that they have confidence in, knowing that that will be both ongoing hours and ongoing income without any variation or fluctuation. Very important when estimating income for Centrelink when it comes to family tax benefits, parenting payments, and also in relation to child support payments. So, you know, this worker has come to this agreement with their employer because it works for them. It also works for their employer. Let's say it's a small retail store. Under this current legislation, if in some circumstance it could potentially be based on some hypothetical scenario, not on the actual scenario of that worker, but some hypothetical made-up scenario somewhere, that worker's penalty rates have been cut. Will this bill require that worker and that employer to exit that agreement and to take up a different agreement directed by this legislation against their own effective flexibility requirements, and what actually suits them and their needs best?
Minister.
The short answer is that it wouldn't change the situation for someone on that kind of an agreement. And one of the points we've been making in advocating for this change is that we are fine with employers, employees, unions negotiating terms that apply to a particular business. And in that negotiation, it may be that the parties agree to make some changes to penalty rates in return for pay rises, or there might be changes to conditions. That's the nature of an agreement. But an award is different, and what this legislation is about is the award. So the award sets the minimum safety net, and what we're saying that in that situation, when there hasn't been an agreement reached in a workplace, that in that situation, it shouldn't be possible to cut penalty rates in the absence of that kind of a negotiation on agreement. But I think you mentioned your daughter's case working for one of the major retailers, and they all have enterprise bargaining agreements that they've reached with their employees and typically with a union. And that's the point we're making, is that if people want to discuss changes to penalty rates, changes to conditions, changes to wage rates in an enterprise level way, then that should be done through an agreement, rather than taking away penalty rates from the minimum standards, which is what's set in an award.
Yeah, Senator Kovacic.
Thank you, Minister. Can I ask then, you made the comment, and I was listening intently to your explanation around an agreement between an employer, an employee and the union. Do you have a concern with the fact that employees and employers may wish to come into these arrangements and into these agreements without the intervention of a union?
Minister.
It's entirely a matter for an individual employer, its workers and the relevant union to come to an agreement around the pay and conditions that are paid in that workplace. Of course, they've got to, operate within the parameters of the law, but that I'm not going to express judgment on whether a particular agreement is a good one or not. That's obviously the role of the Fair Work Commission to oversee that process. I think that I'm remembering now, that's one of the other distinctions between making this change to affect awards and agreements. Agreement making is supervised by the Fair Work Commission to ensure that the parties don't end up worse off, essentially. If someone is paid on an award, there's no supervising process as that employee starts work and gets paid that conditions, that is all done when the award terms are set. And that's why we're saying that when it comes to setting the terms of the award, that penalty rate shouldn't be cut.
Senator Kovacic.
So I'm not sure that clarifies the question that I asked. Is the government, is part of this legislation or the purpose of this legislation a move to ensure that employees and employers are unable to make their own agreements, including flexible working and arrangements in relation to what best suits them without the intervention of a union?
Minister.
Nothing in this bill prevents employers, workers, unions coming to whatever arrangement they want to reach. This bill will also not apply to what are known as individual flexibility agreements. What this bill will do is prevent the minimum standards set by an award cutting penalty rates.
Senator Kovacic.
Thank you. Thinking again about the retrospectivity of this, has the department provided legal advice as to whether the bill's current wording does expose employers to retrospective claims? And if not, was it sought in the first place?
Minister.
The bill is based on departmental advice. I'm sure in the process of that they've taken advice from lawyers, but it's based on the advice from the department that it's not retrospective in its operation.
Senator Kovacic.
Minister, will that advice be released, or will you commit to releasing that advice?
Minister.
I think what I normally do at this point is take that on notice.
Senator Kovacic.
Thank you, Deputy Acting President. What protections will small businesses have against unions bringing applications to vary existing award terms under this bill?
Minister.
If I've understood your question correctly, Senator, you're asking, what protections will there be for small businesses to stop unions seeking to vary awards to make use of this? As I've said many times, that happens on a daily basis, that unions and employer groups seek to vary awards. So I would expect that unions will make all sorts of applications just as employer groups will do. So I can't offer that kind of protection because that's what happens in the Commission every single day.
Senator Kovacic.
Is it your view that the ability to vary the existing terms of awards will increase under the passage of this bill?
Minister.
I'm not sure that anyone will have modelled, the likely number of applications, but just as today there will be unions and employer groups in the Commission seeking to vary the terms and conditions of an award, either to raise pay rates, reduce pay rates, add conditions, take away conditions, then I'm sure some people will make use of this provision once it's passed.
Senator Kovacic.
I'm sure that some people will. I wonder why you didn't model that. Why wouldn't you model to see whether this would actually create a greater incidence of unions looking to vary existing award terms under the bill?
Minister.
I would expect, Senator, that what we'll see is this provision more used as a defensive mechanism by unions if we saw employer groups make an application to the Commission trying to cut penalty rates from an award. This would stop that from happening, rather than unions seeking to vary awards to do something regarding penalty rates. It's more, to my mind at least, that sort of defensive step. And as I've said, there are literally cases in the Commission right now where we're seeing employer groups trying to cut penalty rates from awards, and this would prevent that from happening.
Senator Kovacic.
So if it's primarily a defensive mechanism, then why wasn't there a retrospective element or a retrospectivity element written into the bill? And I also note that Professor Andrew Stewart had specific questions about the drafting of the bill that were left unanswered by the department. So I'd like to get an understanding as to, how these decisions were made in relation to both what the impact of the bill would be, choosing not to draft in a manner that would preclude retrospectivity, when actually saying the Fair Work Commission can deal with it anyway, which then means that the Fair Work Commission now has even more work to do. Why wouldn't you model all of those things when there's a significant impact both on the Commission and on existing award terms?
Minister.
Thanks, Deputy President. Well, because we as a government think that people shouldn't have their penalty rates cut. That's why we're making this change, and that's why we're content to see it go forward. You've obviously asked a number of questions about why we are permitting existing terms and awards to be varied. You characterise that as retrospective because these awards were determined in the past and we're allowing them to be changed. If we stopped awards that might have been decided 5 years ago, 10 years ago, from ever being changed, then people's pay rates wouldn't change, people's conditions wouldn't change. You don't have awards set in stone forever. They change when parties bring applications to the Commission to change those terms, and what we're saying here is that if parties sought to cut penalty rates from those awards, they wouldn't be able to do so.
Senator Kovacic.
Respectfully, Minister, I'm not talking about not changing pay rates or changing penalty rates. It's about the existing agreements between employers and employees as to the broader terms of their employment that they have already come to an agreement on that could be impacted by this legislation, where the legislation is effectively saying, well, bad luck, this applies regardless of an existing agreement that you may have. I'm trying to understand why consideration wasn't given to that. And whilst there is obvious impacts to that to small business, it's obvious that a small business is going to find that harder to manage, than a Coles or a Kmart or a major bank or any other organisation.
Minister.
As I think I've said previously, any agreement that has been reached at an enterprise level, so an enterprise bargaining agreement, an individual flexibility agreement, this bill won't impact on those agreements because they've been reached between employer, employees, and sometimes with the involvement of a union. This is about the award, the minimum standards. I think some of the concern seems to come from a fear that and there have been cases, we all know them, where several years ago the Commission did reduce penalty rates. I think they made a decision in the retail sector a few years ago to reduce penalty rates. This bill would not automatically change those penalty rates back to where they were. It would require a future application, presumably from a union, to increase penalty rates above the level that they are currently set at, whether they've been reduced before or left as they are. So this bill won't overturn, if you like, previous decisions of the Commission on its own. It would take a future application from a union to seek to introduce penalty rates, and as I say, I reckon there's probably unions in the country trying to do that right now, just as unfortunately there are some employer groups trying to cut penalty rates right now.
Senator Kovacic.
Thank you, Minister. Could you please explain how the bill will treat annualised salary arrangements that are already approved by the Commission, and if that's in line with your most recent answer?
Oh, yeah. Yep.
Minister.
I knew I had a piece of paper somewhere. So your question, I think, essentially was how will the new principle impact annualised wage arrangements? The Fair Work Act permits annualised wage arrangement terms in modern awards at section 139, subsection 1, paragraph F. These terms must include safeguards to ensure employees are not disadvantaged. The new principle will apply when the Commission is exercising its powers to make, vary or revoke a modern award. It will be up to the Commission to determine how the principle is interpreted and applied through its usual consultative process with parties. The government is aware of 22 annualised wage arrangement terms in modern awards.
Senator Kovacic.
Thank you. Going back to your previous answer, Minister, in relation to previous attempts to reduce penalty rates, can you confirm whether that relates to the 2016 matter where there was a union negotiated agreement by the SDA which cut penalty rates, and that the Fair Work Commission actually overturned that, and that if that is the case, if the Fair Work Commission were capable of overturning this union-led decision in 2016, is this a reflection of the powers of section 134 of the Act actually already doing what they are intended to do in relation to penalty rates?
Minister.
Thanks, Deputy President. I don't remember the exact circumstances of the case you've referred to or the one that I was referring to before. My recollection is that around about that time there was a decision made by the Commission to vary the terms of an award to reduce penalty rates, as opposed to an agreement. And what I'm saying is that that kind of decision would not be possible after this bill is passed. It wouldn't be possible to cut the penalty rates in the award. But what I'm also saying is that this bill won't automatically overturn that kind of past decision. If someone wants to increase penalty rates from their current level, then they have to apply to the Commission and vary the award. They did that. They had to do that yesterday. They have to do that today. They would have to do that after this bill is passed.
Senator Kovacic.
Thank you. I spoke before about some drafting concerns that Professor Andrew Stewart put to the department. Will the Commission be required to test new arrangements against fringe or extreme scenarios as raised by Professor Stewart? So by fringe or extreme, I mean someone that only works on public holidays or someone that only works on Sundays, rather than an individual's likely patterns of work?
Minister.
Look, I can't predict exactly how the Fair Work Commission will make future decisions based on this bill, but the usual process that the Commission undertakes in an application is to consider all of the evidence that's submitted and reach a fair and reasonable position, and I would expect that's what they do in this case as well.
Senator Kovacic.
In that case, why would you have a view, or would you be able to give us some insight into why the department's responses were so general and deferential to the Commission instead of providing clarity to stakeholders? Like, why can't the department just tell us what is going to happen here or what the general set of rules are, which is, why doesn't it just say, no, absolutely not, we're not going to base this on a hypothetical random scenario of some worker that might just work Sundays or a worker that might just work on public holidays? Why not provide that clarity?
Minister.
Thanks, Deputy President. Well, I mean, we respect the fact that the Fair Work Commission is independent in the decisions it makes on particular cases. We respect the fact that they have discretion when they make their decisions, and we don't want to overly constrain the Fair Work Commission in terms of what they have to consider and what they can't consider. We're setting a principle for the Commission to be governed by or guided by, and then it's a matter for the Commission to interpret the particular facts of a case.
Senator Kovacic.
I'm a bit more confused now. So, Minister, you tell us that this bill is about providing certainty, but you've now just said, in answer to the last couple of questions, that you can't guarantee how the Fair Work Commission will interpret the new provisions of this bill that's meant to provide certainty. So which is it?
Minister.
Well, the bill provides certainty in the sense that it makes clear that penalty rates can't be cut in awards after this is passed. But the Parliament doesn't ever seek to tell the Commission what it must decide on every single case. That's the point of the Commission, is to weigh up the evidence, apply its discretion. I remember having a long debate with Senator Cash along similar lines with one of the workplace relations bills that we passed last term, where my answer to many of her questions was, it's a matter for the Commission. She seemed to think that was, I'm not sure if she thought it was laughable, horrific, it was her usual mock horror that we're seeing again this week. But that's how it works, is that the Commission has discretion to make decisions. What we're doing here is setting the principle that the Commission needs to consider.
Senator Kovacic.
I understand that that's the function of the Commission, and you know that their purpose or their job is to weigh up evidence and apply discretion. But how are they going to be able to do that now based on this legislation? Because this has now become prescriptive. It actually can't say, well, weighing up the balance of things, this is fair and reasonable. They're actually being told, well, we actually have to do this.
Minister.
I think this part of the discussion stemmed from you putting forward that the situation where I think what you called fringe cases might be provided to the Commission. And what I'm saying is that the Commission, when making its decision, will consider all of the evidence, will come up with a fair and reasonable decision. But yes, we are seeking to tell the Commission in this bill that it can't cut penalty rates from a modern award. Just as I'm sure I could find you a couple of hundred other sections in the Fair Work Act which give the Commission direction about what it can and can't do. But then they operate within those boundaries to consider the facts of a particular case to make a decision.
Senator Kovacic.
Do you consider the wages for employees of small businesses to be fringe issues?
Minister.
I absolutely do not consider the wages earned by employees of small businesses to be fringe issues. I think they're really important issues, and that's why I'm proud to be part of a Labor government that is increasing the wages of workers in small businesses and big businesses after 10 years of wage suppression by the Coalition.
Senator Kovacic.
Thank you. I'm very proud to be a part of the Liberal Party that wants to ensure that small businesses remain in existence so that they continue to employ Australian workers and they can have the flexibility of choice of working for local Australian small businesses rather than being pushed to institutional and large corporations. Minister, can you please tell me why we're proceeding with this legislation right now when there are fundamental questions about its implementation still unresolved? And I speak to the impacts to small business, I speak to retrospectivity, I speak to ambiguity in the language and unintended consequences. Why don't we just, take some time to actually ensure that we don't have those problems, given that nothing is actually going to change today or tomorrow, as you state?
Minister.
Well, the reason we're doing this, Senator Kovacic, is because we don't want to see people lose their penalty rates. That is literally under threat right now in 2 separate cases in the Fair Work Commission. And even if it weren't for the fact that those cases are before the Fair Work Commission now, This is about putting in place a broad principle that applies forever, whether it be to those couple of cases or more generally into the future. We don't want to see penalty rates cut, and that's why we're seeking to pass this bill.
Senator Kovacic.
So what I want to get an understanding of is how does the government then justify removing the ability for employees to agree to higher base salaries in lieu of penalty rates when these arrangements provide income stability? And I'll use another example. Many major lenders in this country, when they assess borrowing capacity for a home loan, will assess penalty rates and overtime rates as a lower percentage because of the variation or the instability of those hours. Why shouldn't an employee be able to negotiate with their employer a higher flat rate that on measure they are delivered a higher base salary on to provide them that income stability? Why can't they choose to do that?
Minister.
Thanks, Deputy President. As I said earlier, we're entirely comfortable with workers and their employers reaching agreements about their pay and conditions, and that is what the enterprise bargaining system operates for. But we don't think it's appropriate that the minimum conditions that are set in an award should allow for penalty rates to be cut.
Senator Kovacic.
Minister, could you tell me what consideration was given to the evidence from women who face significant difficulties with Centrelink and child support due to variable penalty rate income, if any?
Sorry, would you mind just repeating that question, Senator?
I'll try and remember
Senator
most of
Kovacic.
how I said it. Minister, could you please tell me what consideration was given to evidence from women who face significant difficulties with Centrelink and child support due to variable penalty rate income, if any? So to clarify that, what consideration was given to the fact that some women may choose to have a flat rate income that suits them better for those purposes in relation to reporting of income to government agencies?
Minister.
Thanks, Deputy President. Look, I think my answer is the same, in that the ability for those women to reach those kind of agreements will remain in place after this bill is passed. They will still have the ability to negotiate and be part of an enterprise bargaining agreement, just as they do now. More generally, in terms of how this bill impacts on women, the bill would have a positive impact for women who make up the majority of the award-reliant employees, nearly 60%. So nearly 60% of award-based employees are women. So this will be protecting their penalty rates. Women are also overrepresented in part-time work as workers with care responsibilities and in industries where enterprise bargaining agreements are less common. So by ensuring that penalty and overtime rates in modern awards are not reduced in the future, this bill helps protect take-home pay for these women. But as I say, they continue to have the ability to reach agreements just as they do now.
Senator Kovacic.
Thank you, Minister. My concern is in relation to how it will be assessed. And it won't be assessed necessarily on their own individual circumstances. So what I'm trying to understand is why an employee like the one that I've just described should be denied the arrangement that they prefer, that suits them, that suits their family, that also suits their employer, simply because a hypothetical worker somewhere else might be worse off in a hypothetical scenario. I'm interested in understanding why the needs of a real worker are being overlooked for the needs of a hypothetical potential worker.
Minister.
Thanks, Deputy President. I'm reminded that in addition to enterprise bargaining agreements being available for women in that situation, I think I said earlier that this bill won't have any impact on individual flexibility agreements. So there still are opportunities for women in that situation to reach agreements with their employers. What won't be possible is for an employer to say to a woman, in the instances you're talking about, you're going to be paid the award, and what that means is that you won't get penalty rates because the award doesn't allow for penalty rates any longer. That's what would be stopped.
Senator Kovacic.
So I think the question that I'm thinking about here is in relation to EBAs and IFAs, which is a different matter and relate more so to larger organisations, but I'll come back to that later. My concern in relation to this is this government states that it supports flexibility. And there are many people now, as we saw during the election period, that talked about the importance of workplace flexibility, in particular of working from home, of negotiating those terms with their employers. My concern is how this bill, which becomes incredibly prescriptive in relation to certain elements, how does that align with the government's stated support of workplace flexibility, particularly as it comes to an employee and an employer being able to come to a mutual agreement?
Minister.
This bill still allows an enormous amount of flexibility when it comes to workplace arrangements. What it stops is from people having their penalty rates cut without adequate compensation for that. There will still be parties can still seek exemption rates in an award, which would take into account the loss of penalty rates, but they need to be properly compensated for that. So it's about not cutting penalty rates and leaving people worse off.
Senator Kovacic.
Thank you, Minister. Does that exemption rate calculation apply to that individual employee or to hypothetical potential employees? Or hypothetical scenarios?
Minister.
As I understand it, those exemption rates would need to operate in a way that didn't leave any employee worse off.
Senator Kovacic.
So effectively, even though that individual employee who had negotiated that agreement with their employer is better off and they are happy with that arrangement, under the terms of this bill, they would not be able to continue in that arrangement if some other worker somewhere would have been worse off under that same arrangement.
Minister.
I think the most likely scenario where what you've put forward would occur could be dealt with through an individual flexibility agreement, where an individual employee reaches an agreement with their employer and they can negotiate the terms and conditions of that suit them, obviously within the boundaries of the legislation.
Senator Kovacic.
Minister, do you acknowledge that IFAs are acknowledged for their fragility and are not perhaps a best practice measure for agreements between employers and employees?
Minister.
Personally, I'm a fan of enterprise-level bargaining and collective agreements, but there are other arrangements possible under the Act.
So to be clear, the only option for that employee that wishes and that scenario is actually suitable for them and it's best for them is to enter into an EBA or an IFA. They cannot remain in that agreement even though they are better off under it.
If